Hi, I'm Janice Switlo, and today I want to just touch further upon terminology, specifically talking treaty, as the title to the episode mentions. I earlier spoke about how to introduce yourself and not describe yourself as a legal document. And I want to explain a little further that things are very different today than they were in the time of Indigenous nationals' grandparents' time. And that is to caution today against using the term treaty rights. I'm exercising my treaty rights, or I'm trying to protect my treaty rights. The concept of treaty rights is now terminology that's been encompassed and enclosed within the Section 35 domestic doctrine. And as such, suggests that they're not actually rights. Why? Because that doctrine sets the stage for how to lawfully push you aside and lawfully infringe. These are terms from the doctrine itself, from the cases that determine the doctrine. Infringe, quote-unquote, Aboriginal rights and treaty rights. It's critical to drop that terminology, to not speak of treaty rights, but rather to speak about the existence of treaty and to speak about your jurisdiction. There are two parties to the treaty, a third, of course, the creator, but I'm not going to get into that discussion. Jurisdiction, continuing original sovereignty in the Indigenous nations that granted permissions to the Crown through the treaties. And the kinds of permissions granted to the Crown allow for the Crown to exercise partial political sovereignty, and is the first step that the Crown obtained in order to establish her Canadian governments in this part of the world. The jurisdictions, however, are distinct. There was no giving up of jurisdiction. There was only granting of permissions, which can limit some aspects of the whole sovereignty still preserved in the hands of the Indigenous nations. So, talk nation, not I'm Treaty 6, talk nation, the name of your nation, and talk about your nation having treaties that have granted permissions to the Crown. And what has been granted to the Crown forms the upper limit of what her Canadian governments can exercise. In other words, when 1982 Constitution Act was passed, it didn't give Canadian governments anything more than the Crown herself had obtained. It's a very different scenario here because remember, there was no war, there was no conquering, there was a commercial basis that formed the original relationship, and the treaty documents themselves do not indicate and do not say this is a sale. This is not a conveyance of whole underlying title, and there is no giving up or surrendering of full jurisdiction and sovereignty. So these are important things to remember. It's no longer, if you just speak about treaty rights, and that's kind of the habit because that's the way, it's been discussed in the past. But now to use that term says to the world that you are relying upon and embracing the Section 35 doctrine. So that's all I have to say. Avoid that, please.